Good evening and welcome to the September 2016 Richardson Law Office's Legal Hangout. Uh, it's ordinarily shown on the fourth Thursday of the month, but for some reason last Thursday, the 22nd, we had some technical problems, and I wasn't aware of it until afterwards. One of the viewers commented that my audio was off, sounding a bit like Mickey Mouse on helium while he was taking speed. So it sounded off and completely unintelligible. So I decided to take another shot at it this evening, September 29th. And we're going to talk about this month preparing a will, living will, and a power of attorney here in New Jersey. Now, last month in our August Hangout, I talked about why it's important to have these documents here in New Jersey and what can happen if you don't have them, and the perils of not having one. So this month is the follow-up and talking about, all right, you watched last month's episode and you decided, yep, Steve's right, I should have a will at the very least, and hopefully a living will and a power of attorney as well. But how do I go about doing that? Do I see a lawyer? Do I just go to an office supply store and get some forms? But no matter what you do, there's certain things you need to think about first, and decisions that you need to make before you either go to see that attorney or sit down with those office supply store forms and fill them out. Some things you need to know. So that's what this month's Hangout's all about. Now, I'm a lawyer, it's a law firm, this is legal stuff, so of course there has to be a couple disclaimers. Now, first of all, this is just for New Jersey. Laws having to do with this topic are fairly standard throughout the country from state to state, but there are some differences. So I just want to make you aware, I'm just talking about here in New Jersey, preparing these documents. If you're watching me from another state, it might be some good general advice, but don't put any definite faith in it from a legal standpoint. It's really only for New Jersey residents. Second of all, this Hangout is not a how-to. None of the Hangouts or any of the materials I provide constitute a how-to or in any way a substitute for a meeting with an attorney and having an attorney handle a matter for you. But at least this will give you a leg up. If you decide to see an attorney, which I hope you will at least have the information together that that lawyer is going to ask for in the process of preparing those documents for you. So let's talk about these. Now, again, in last month's show, I talked about what these documents are. I just want to talk briefly. Obviously, a will. Everyone pretty much knows what a will is. It's basically a set of written instructions on how you want your stuff taken care of after your death and who's going to take care of it for you. Until you're dead, it's just a piece of paper, and it can be changed, modified, torn up, rewritten, whatever, but it only comes into effect upon your death. Second document is a power of attorney. This allows someone to be you. Either to a limited extent or a very broad extent, depending upon how you write the document. You choose someone who's going to be your attorney in fact, and he or she is going to be you within the scope of that power of attorney. Now, the general powers of attorney that I draft are very extensive and list all sorts of things and that you can do that pretty much allows you to stand in the shoes of somebody else and be that person. You're going to be limited powers of attorney, which we're not really talking about here, but where, for example, if you're selling your home or buying your home, you have a real estate transaction and you're a married couple and one spouse can't make it to the closing. So that spouse may sign a limited power of attorney authorizing the other spouse to sign on his or her behalf. Very limited in scope and what that person can do. And obviously, once the closing is over, then that power of attorney is pretty much moot. But we're talking about general powers of attorney that are used so that somebody else can handle your affairs should you become disabled, still alive but disabled or unable to handle your own affairs for one reason or another. The third is called a living will, just that. It's mainly for medical decisions about treatment, et cetera, and comes into play automatically. And should a medical provider, like a hospital or a doctor, whatever, needs someone to make those decisions, then the holder of, and you can't make them yourself, then the holder of that living will, the proxy, is empowered to make those decisions based on the instructions in the living will. So those are the three documents. Let's talk about what you need to think about to prepare each one. Let's start with a will. Now, first decision you have to make is, who's your executor going to be? Who's going to be the person that carries out your wishes in the will? This is a careful decision to make. Now, you need a primary executor and an alternate, just in case your primary executor predeceases you, becomes ill, moves out of the state or out of the country, or for one reason or another is not able to fulfill the duties of executor. You have a backup. I do not recommend having co-executors. Have one boss. Co-executors, there are too many problems can arise from having them, mainly because you have two people. If they can't agree, there's a logjam. There's a dispute, a tie that can't be broken. So one person's in charge, calling the shots, one executor with an alternate. With a married couple, that executor is usually the surviving spouse. And in the alternative, either an adult child, parent, brother or sister, close family member as the alternate. For a single person, obviously is not going to be the surviving spouse, and it's going to be, again, either a parent, sibling, that sort of thing, but someone you trust. And that's very important. It's got to be a trustworthy person, someone that can handle the responsibility of administering your estate. So do that. So also, one more thing, excuse me, how good that person is with money must be maybe an honest person, trustworthy person, or even if there's a problem. Ordinarily, in New Jersey, you probate a will, the surrogate's office is going to require that executor post a bond. There will be evaluation of the estate, get an idea of how much it's worth, and then the executor would have to purchase a bond, usually good for 1 year, and pay a premium on that bond based on the value of the estate. So that if anything happens, if an estate asset is lost or there's a problem with it or whatever, then the heirs have some protection. They have the ability to claim on the bond. But that premium is an expense on the estate. So that's one more bill that has to be paid and that much less that the heirs receive. So if this person you trust is good with money, you can handle your estate, you're going to want to put something in the will that executor may serve without posting a bond. It's something to think about. Do you have minor children? That's an issue. Hopefully they'll be fully grown by the time you pass on. But you need to make arrangements in your will for those minor children. One thing you should name a guardian. Who's going to look after your children if you're gone? Now, if it's surviving spouse, obviously if it's surviving spouse takes care of it. But what happens if your spouse predeceases you and you never got around to writing a new will? So just like you want an alternate executor from your surviving spouse, you're going to want a guardian for your children, somebody that you trust to raise your children after you're gone. Obviously someone that you trust is trustworthy, and so you're going to want to name a guardian in your will. You're going to want to make sure that these minor children are not inheriting a lot of money. Okay, they're minors. So your will should have some sort of trust provision that if they are inheriting anything under the will, that it be placed into trust until they reach a certain age. And that money can be used by a trustee to support them, pay for their education, that sort of thing. And then when they reach a particular age, then that trust terminates and the trustee distributes the remaining contents of the trust to that child beneficiary. The age of majority is 18, but to be honest with you, I recommend an age for these trusts of at least 22 years old. That allows them to grow up a little bit, be a little bit more mature. It also is most likely to be at a point where they've graduated from college and their educational needs are most likely have been met. And if they need to go on to medical school, law school, graduate school, or whatever, they will hopefully have some maturity to be able to handle that money and pour it out. So I really look at a minimum age for these trusts at the age of 22. Now, I've been talking about a trustee. That's somebody else you got to name. Who's going to look after the money? And now it could be the guardian. That would certainly make it easier. The guardian, the person that's raising your children after you're gone, also has easier access to the money as the trustee. So you can consider that. But the person that you trust most to raise your children may not be the best person with money. So you may want to have somebody else, somebody who's good with money, handle that trust, especially if it's potentially a lot of money. Make sure it's handled and invested properly, and then distributed to your child appropriately for their support or education. So be careful, in naming a trustee as well. Again, one trustee, one boss. You have more than one, decisions can't be made, money can be held up, and there can be a problem. And you should have a backup in addition to an executor and a guardian, where there's a primary and a backup. Same thing for a trustee. You always want to have a plan B. So in case you have a problem with that that person predeceasing you, there's somebody else that can handle it. Spouse is beneficiary. Now, excuse me, most people, as said, married couple, everything to my spouse, and if my spouse predeceases me, everything to my children. Pretty straightforward as far as distribution is concerned, but obviously other considerations. Now, do you want all of your assets to go to your spouse? You may not want that. Maybe you want them to get less than your full estate and give some of it to other people. Perhaps it's a second marriage or some such thing. But just bear in mind that you cannot completely disinherit your spouse under New Jersey law. Your spouse is entitled to something called an elective share of at least 1/3 of the estate. So you can redirect and give to other people up to 2/3 of your estate, but that your surviving spouse is entitled to at least a 1/3 share. Now, if your spouse agrees to take less and say, all right, I'll only take 25% or 20%, I know you want children from your marriage to get more, then fine. But just be aware that if that spouse changes his or her mind after you die, then it can be subject to challenge under an elective 1/3. So also be aware that from a tax standpoint, that anything that passes to the spouse passes tax-free. It's called a marital deduction. Now, if you have a large estate that may be subject to tax, which I'll get into in a minute, there are some ways through the use of trusts that you can maximize that deduction as far as money that may be subject to tax. But that's really a subject for another hangout or to talk to an attorney that doesn't do just routine wills, but actually does tax planning for estates. Now, so we've dealt with your executor, guardian for your children, trustee for your children, your surviving spouse, as far as that's concerned. Now let's talk about what happens to your stuff. Where do you want it to go? What are your instructions to your executor? Well, usually the first thing gets paid is funeral expenses and the bills associated with the last illness, which led to the death. Then any taxes that are due, and then comes up what are called specific bequests, particular items. I want Aunt Mary to get my mother's pearls, or some such thing as that. But specifically identify an asset that you want to go to that person. Specific bequests, and after you've specifically directed a particular asset to a particular heir, the rest of your estate, called the residue, you say, all right, and everything else goes to so-and-so, and you name who gets the residue. But let's talk for a minute about specific bequests. Now, make sure that you list it in your will and talk about it with enough specificity that the executor knows what you're talking about. Okay. If you have 2 sets of pearls and you just say the pearl necklace to so-and-so. Well, what about the other pearl necklace? Does that go into the residue with everything else, or does that go to somebody? And which pearl necklace is it? Is it the Mickey Motos, the Majorcas? Which pearl necklace? So do your executor a favor, and if you're doing these specific bequests, be specific in your will, so that they say, "Oh, that's such and such," and I know for sure that's what you meant, and I'll make sure that this person gets it. So also make sure the list is in your will. Sometimes people will say, "I want the specific bequests of assets go to certain people according to a list attached to my will." Well, that may make it easier to change that list as you go through your life and change your mind about who gets what without changing your will. But what if that list gets separated from the will and lost or destroyed? And then you have the will, but you don't have the attached list. So that can be a problem. So I really recommend that specific bequests be in the actual will. Then the residue, as I said, everything else in the estate that goes out and who it goes to. It's usually, when you're dealing with the residue is sold, have an estate sale, whatever it is, residue sold, and that money is then divvied up according to your instructions on the residue. If you don't want to do that, you don't want it to be sold, you want to make sure so-and-so gets it, then be specific in the will. Okay. You may not want that the house, for example, sold. You want to make sure it's there for your children to live in. So you say that. Just be aware that that can lead to problems where one of them wants to live in it and the other one, they don't want the house, they just want the money. And now you've got what's called a partition action, that they're fighting of heirs over the house. So to bear that in mind. So usually the contents of the residue are sold to raise money, and then the money is split up. Now, how is it split up? Now, there are 2 ways to do it. And a little legalese here. The terms are called per stirpes and per capita. And let's say you have 2 children, and they're both grown, and one child has 3 children, and the other child has 2 children. Well, the child with 3 children predeceases you. Well, then your will usually says that it would then go to the children of that predeceased child, down another generation in your issue. But how is it distributed? Under per stirpes, what happens is you have 2 children, and that your estate is split in half. And the child that predeceased you, their 1/2 is then divided up among their 3 children. And then the surviving child gets the other half. That's usually what most people pick. Tends to be well, it is the default unless you mention otherwise. So if you say nothing, it's per stirpes, although most lawyers will add the term per stirpes. Then there's per capita, and per capita works a little differently. Same situation, 2 children, one with 3 children of their own and the other with 2. Same parent of 3 children predeceases. What happens? Well, in per capita, you add up who's left. So your heirs are 3 grandchildren and a child, 4 parts, each one getting 25%. Under per stirpes, the surviving child would get half, 50%, and the other 50% would be divided among the 3 children, and a little bit more than 8% each to each child, as opposed to 25% under per capita. So most people don't choose that, but if that sounds like what you want to make sure that you know that the distribution to your heirs and the residue is per capita. Now, in general, I mentioned spouses. You can't disinherit a spouse. Other family members, usually children, can be disinherited, but you should really do it. There's a particular way to do it. Let's say you have 3 children and you provide for 2 of them in your will, and you don't say anything about the third one. You just leave them out, and you figured, okay, I've disinherited them. Well, that's not ultimately what happens, because that child who's not named in the will can say, oh, mom always meant that I should share with the other 2 kids, my brother and my sister, and that's just a drafting error. She left me out. The lawyer screwed up or whatever and didn't include me. I should get my equal share. And that can lead to a fight and problems and attorney's fees and everything else, and then everybody's inheritance goes down. So avoid that. Be specific. Say in your will, I'm not providing for Johnny. Okay, that third child, mention specifically that you are not providing for that child. The usual language is put in. What I use is I say, I specifically do not provide for my son Johnny, as I believe I have provided for him sufficiently during my lifetime. So it's a tactful way of disinheriting someone, but still specifically saying that that's what you're doing. So they can't come back later and say, mom made a mistake or the lawyer made a mistake. So be specific on that. That's it for wills. I mean, I'm sure there's a lot more to talk about with wills, and you're an attorney that you talk to in your particular situation may raise other issues. And just a couple things to be aware of. I mentioned taxes. I'm not a tax attorney. I don't involve estate planning, so I'm not going to talk about that. But I am going to alert you so you can have an idea of whether you need to see an estate planner as opposed to just an attorney to draft you a will. At the federal level, there is estate tax, and that works by the size of your estate. If your estate is not big enough, then there are no federal estate taxes. Now, how much is big enough? Well, as of 2016, the year of this Hangout, it's $5.45 million. So the value of your estate, which will be determined by an attorney and or an appraiser, when you look at the value of estate, if you think you're anywhere close to that, you should do a valuation and see if you need tax planning. But anything over that $5.45 million can be subject to estate tax. Now, this is called a unified deduction on the federal level and includes not only estate tax, but gift tax. So if you give a large gift of money or an asset to somebody during your lifetime and don't want to pay gift tax on it, then that can whittle away at that exemption. So there are certain senses where it could be less than $5.45 million, but you just have to be aware of that. Now in New Jersey, good old New Jersey and taxes, there's actually 2 types of taxes in the states. There's estate tax and there's inheritance tax, and they work differently. Inheritance tax is whether or not you pay taxes is based on who inherits. So you have Class A beneficiaries, your children, your grandchildren, your parents. Class A beneficiaries, they do not, whatever they inherit, there's no inheritance tax on it. Uh, and then as the further out you get, cousins, aunts and uncles, non-family members, they can be subject to tax. So just be aware of that from an inheritance tax standpoint. Then there's estate tax. Now, estate tax says we don't care who's inheriting. What we care about is how much the estate is worth, just like the federal taxes. And for as of 2016, again, it's $675,000. So if you think your estate may be worth more than that, then you need to look at potential tax planning. So that's wills. Now, let's talk about powers of attorney. Obviously, first, choosing your representative. Who is going to hold power of attorney for you? Should be someone you trust, really trust, because this power of attorney, depending on how, the broader it is, the more that person can stand in your shoes and become you. And once they have that power, they can rob you blind. They can do what you can do, and it can be a problem. So make sure you trust the person that you're naming as your attorney in fact. And also have an alternate. Again, just like wills, you want an alternate for everybody, a plan B. Okay. So if that person's unavailable, dead, sick, whatever, you have somebody else as a backup. Now, these powers of attorney are usually triggered by a disability. The purpose of doing this, obviously, is to avoid the expense of a guardianship action. You become unable to handle your own affairs, slip into a coma, slip into dementia, whatever. Upon the proving of that disability, and the power of attorney would define what that is, then this springs an action and names somebody to take care of your affairs. Again, only one at a time. Okay, not more than one. You have an alternate, but just one person. I hate to keep hammering on that, but it's important. Make sure that they're local. Okay, they have to stand in your shoes and take care of your affairs. They shouldn't be out of state, out of the country, hours away. Excuse me. So make sure they're local and able to step in when needed and handle your matters, handle your affairs, pay your bills, whatever else needs to be done. So make sure they're local. And make sure that you're comfortable with what you're setting forth that person can or can't do. A durable power of attorney, the kind I'm talking about, you're really going to need them to be you. So you don't want to be too narrow and leave something out. And make sure they're aware of all their responsibilities. And make sure they know the information they need to know to carry out these responsibilities. Make sure they know where your bank accounts are, where your checkbook is, how to get into your computer for all your financial records, how to get into your safe deposit box if you have one, to get important documents like a deed to a house in case you need to, they need to sell that house, investments you may have, retirement investments. If you contribute regularly to an IRA and you need to make the contribution this year and you can't do it, just make sure that that person knows what they need to know to take care of your affairs. And make sure they have a copy of the power of attorney. All right, maybe an electronic and a paper one, so they're able to carry out your wishes and have that authority. Make sure they're not digging around trying to find it when they really need it. That's powers of attorney. Now, finally, a living will. Now, again, you're choosing a personal representative, and all of the previous requirements hold true as far as someone you trust, someone that's local, et cetera, et cetera. But also, with a living will, there's an additional consideration, and that is you want to make sure you're not burdening them with more than they can handle. When it comes to making financial decisions, excuse me, not financial, but making healthcare decisions, especially end of life decisions, that they are of the same mind as you. A lot of times, religious beliefs can come into play. Maybe there's a conflict of beliefs, and you're making that person uncomfortable by saying, okay, if this happens, I want you to terminate life support and let me die. Well, they may not believe that. I mean, be a very difficult decision for them to make. So make sure you're of the same mind and make sure that this is a person that can really handle it. Then next thing you need to be sure of, and this gets ghoulish, I'll tell you right now, and nobody likes to think about it, but you have to. When it comes to end of life decisions, what constitutes death? You may think it's simple, but it isn't. Does death mean a cessation of brain activity? You may still be breathing, your heart may still be beating, but you're pretty much brain dead. Is that death? There are some religions and religious beliefs that believe, no, you're still breathing, heart's still beating, you're still alive. So you may, a little introspection on beliefs and what constitutes death. Is it brain death, or is it irreversible cessation of cardiopulmonary function? Fancy way of saying you're not breathing and your heart's not going anymore. And that's death. So to say, okay, that's the definition of death. If my doctor says, according to that definition, I'm dead, then withhold all extreme measures to keep me alive and let me die. So you need to consider a definition of death. Now, next thing, how imminent is your death? You're terminal, and if you're, but how imminent does it have to be? Is it you expect to die within a certain number of days, weeks, months? All right, give your proxy a clue as to what it is. And because we're talking about extraordinary measures to keep you alive, in other words, a DNR, a do not resuscitate. If something should happen, you have a coronary event, that sort of thing, and you have weeks to live, do you want to just let it go? Don't resuscitate me. But you need to define it in terms of what is dying as far as a period of time is concerned. Ghoulish, I know, but you got to think about this stuff. And what are extraordinary measures to prolong life? Again, the end of life issue, which is often the big issue here. What constitutes extraordinary measures? And your living will should set that forth. Is it a resuscitator, where you're basically a machine is breathing for you, circulating your blood for you? Or are you, like, again, we're going back to brain death or cessation of breathing and heartbeat, is what keeping you alive, IV nourishment and hydration. There are, again, religious beliefs, Roman Catholicism, for example, that says that's not extraordinary measure. That's basically food and water. Withholding that basically starves the person to death. Lets them die of thirst. It's not really, you can't, without violating that belief, if that's your belief, that comes into what an extraordinary measure is. How much should they do to keep you alive? Up to including a DNR. So give that some thought. Now, another consideration, you're a woman, you're a childbearing age, and you're in a situation where you're pregnant. What do? The doctor says, well, if she's kept alive to term, the baby can be delivered, and that baby will live. And do you want to be kept alive long enough to deliver that child? Again, that's specific religious beliefs. Again, Roman Catholicism believes that to be kept alive until that baby can be delivered, save that life. So your living will should reflect that if that is your belief and if that's what you want. So you need to consider that. Do you want to be an organ donor? You can put that in your living will. If you pass away, do you want your organs to be harvested? You can donate your body to science. You designate a medical school. Medical schools need cadavers all the time. And if you don't care, if you want to specify that, your living will can say that as well. So that's something else to consider. But enough of that. Talked enough about ghoulish matters and living wills. That's it for this month's Hangout. We've been over half an hour, so it usually doesn't run this long. So lots of good stuff. That's our topic now. If you liked this Hangout, like this video, be sure to click the thumbs up button underneath the video. And if you like the content of this channel, be sure to subscribe to the channel and click the subscribe button. Now, next month's Hangout for October, it will be on October 27th at 5 p.m. And we're going to talk about bankruptcy and divorce. Oftentimes, divorce comes about because of financial difficulties, and bankruptcy can be a good strategy, a good part of your divorce strategy. And there are issues that come up about bankruptcy that are specific and somewhat unique to the divorce context. So that'll be the topic of next month's Hangout. I'll deal with bankruptcy issues in the context of divorce. If you have any questions on this topic, if you're getting divorced here in New Jersey, again, this is all New Jersey divorce, then be sure to, you can either email me at steve@richardsonlawoffices.com or tweet me at @sjrlaw, the question, and I will attempt to answer it in next month's Hangout. But that's it for this month. I will see you in October, talk about bankruptcy and divorce. Good night.